Students, today let us solve one problem with regard to the Partnership Act. Here, as you know that there are different kinds of partners are there. There may be active partner, there may be dormant partner, there may be partner for profit only, there may be nominal partner, and there will be a sub partner also. Likewise, there are different partners are there. There are different kinds of partners are there. Here, the problems will be given on any of the aspects. For example, what is the compulsory thing with regard to the partner when he is going to retire? What are all the duties he has to follow? And on behalf of the firm, who is responsible? Who should be represented on behalf of the firm? And who can represent on behalf of the firm? For example, who can file the case? Against whom the cases can be filed? Likewise, there are certain things are there. So, here, with regard to the while analyzing the types of partners, you know that an active partner is going to be represented on behalf of the company. So, in all the times, he is going to be represented on behalf of the company. So, it is his duty to give the notice to the public when he is going to get retired. So, if he doesn't give the public notice, what will happen? The public, they are under the impression that the so-and-so is still is acting as the partner, so that they believe that that person is a partner of that firm, and they may invest the money, they may transact with the partnership firm, hoping that certain person is still he is a partner of that firm. So at the time, the person who is an active partner who does not give the notice to the public, the procedure for giving the notice is that he has to declare his retirement before the register of firms. So thereby it should be declared to the public. So either he can do or the partnership firm can do. So there are certain aspects are there. Why, what are all the liability if the partnership firm does not do, the certain person has been retired. So here we are discussing only with regard to the person, the active partner. If it doesn't give the notice, what is his liability? How long he is going to be? What are all the liabilities he has to bear with regard to the transactions? So here, one more thing, you know that while discussing the section 24, what has been said in the section 24 of the Indian Partnership Act, effect of notice to an active partner, that is acting partner. For example, if any third person wants to give the notice to the partnership firm, if they give the notice to the acting partner, it is more than enough, as if the notice has been served to the partnership firm. That means there are so many numbers of members will be there, so many partners will be there in the partnership firm. If public notice has been given to a person who is an acting partner, then it is presumed, it is deemed that notice has been served to the partnership firm. So this is the thing. Here we are going to discuss with regard to the problem where active partner who is a partner in a firm where there are so many other partners will be there, and if it does not give the public notice, what is his liability? So in this way, the problem will be given. So I have chosen the recent, very recent problem from KCLU examination, last exam, February-March examination, whereby it is for 100 marks and the problem is for 10 marks. And in 80-20 scheme, you are having for 6 marks. But same problem will be given. Only if you write the steps and if you write the answer for those steps, is more than enough. So why I am giving so much of stress, importance with regard to the problems while analyzing the concepts means, here if I do the problems at the end, you don't remember. So that's why I am doing the problems. I wanted to cover all the problems from the 2011 up to 2021. So here what happens, and as you know that with regard to the method which we are going to follow with regard to the FIRAC, you know what is meant by FIRAC, you know there FIRAC means that is we have to simplify the facts, we have to frame the issues, it may be one or more than one, and we have to write the provision of law. It may be question of law or question of fact. What the court will do while you are going to be practice as lawyers or advocate, if the court does not find the answer in the question of law, it will go to the question of fact. So here what we have to write in the rule, we have to write the question of law only. Here we have to write the provision of law. If it is the constitution, we have to write the articles. If it is the any statutory enactments, we have to write the sections. If you don't have the any articles or section like law of torts, administrative law or anything, then we have to write just the name of the concept. And we have to write the settled law. And we have to write the decided case law. Invariably, there will be a settled case law will be there, but it's not compulsory. So I used to tell in all my this video solving videos, I used to give importance with regard to this thing. And we have to analyze this one. We have to make the analysis. Then we have to give the conclusion. So if students straight away they jump into conclusion, if they solve this problem as they know, whatever how they are going to write the answer for theory questions, then definitely there are less chances of getting the marks. Here, for example, here it has been given X is an active partner of a firm with Y and Z. X retains without giving a public notice whether X is liable to the creditor in respect of a loan advanced after his retirement decide. So this aspect we can see while deciding the types of partners, while looking into the outgoing partner, while analyzing the holding out under section 28, while analyzing the section 24 with regard to the notice given to the acting partner. That means here we know that it is he has to give the notice, otherwise he will be held liable. What we'll do, we'll just write, just he is a retiring partner, so that's why he has to give the public notice, otherwise he will be held liable. Whether the valuer can give the marks, complete marks, this one, if it is for 10 marks, whether valuer could be able to give 10 marks for this one. If you just write yes or no, decide means certain students they will write yes, he will be liable. So if you write that one, whether you are going to get the marks, no probably you know. Every student they are cursing the Karnataka State Law University because they don't get the good marks. The university is not valuing. Probably you know recent thing. Certain students they have been promoted. On what basis they have been promoted? On the basis of the previous semester marks. With the previous semester's marks, what they have done? They have not been get through in the previous semester marks, in the previous semester examination. How can the university can promote? So those things are there. So here there are certain rules and regulations are there with regard to the any giving the passing percentage. So in case LU, we are having 40% aggregate passing percentage should be there. So that is the thing. So here that is the internal marks will be there, external marks will be there. So likewise it may be likewise there are that in the 80-20 scheme the passing percentage is different. With regard to the 100 marks the passing percentage is different. Likewise there are certain guidelines are there. Here I am not telling you with regard to the how much marks you have to score. Here I am telling you, you understand the problems and you try to solve the problems in these vertical steps. Here if you just write yes or no, if you just write yes or no, it is not the you could not be able to get the good marks. That's why what I want you to follow, you follow the procedure which has been internationally what you call accepted pattern of problem solving. So here what we have to see, here we have to simplify the facts. So how we are going to simplify the facts? There was a partnership firm consisting of X, Y and Z. X was the active partner of this partnership firm. Okay, X retires without giving public notice about his retirement. So this is the facts, simplified facts. So what should be the issue? Here the issue is that whether X is liable to the creditor, whether X is liable to the creditor in respect of a loan advanced after his retirement, whether X is liable to the creditor in respect of a loan advanced after his retirement. So this is the issue. So this is the issue between the what you call the creditor and the active partner, whether the person will be hold liable. Here hold liable means with regard when we utter the word hold liable, then the doctrine of holding out will come into existence. So what is meant by doctrine of holding out? This aspect we have seen under the contract of agency also. Here anyone who by words spoken or written or by conduct represents himself or knowingly permits himself to be represented to be a partner in a firm is liable as a partner in that firm to anyone who has on the faith of any such representation given credit to the firm, whether the person representing himself or represented to be a partner does or does not know that the representation has reached the person, so giving the credit. That means according to the law of estoppel, I will simplify it. If a person by his representation induces another to do some act which he would not have done otherwise, then the person making the representation is not allowed to deny what he asserted earlier. That means what it says, that means here the public will believe that X is still is acting as an active partner. So doctrine of holding out will apply here. So this is a branch of law of estoppel. So what he has to do, he has to make it clear to the public that he is no longer remains as a partner to the said the partnership firm. Then if the public unknowingly with regard to this one, they can be, it is their personal liability. So we have to highlight these things in the provision of law with regard to these things. So here rights and duties of outgoing partner. So what are all the things which will be attached here? That is the rights and duties of the outgoing partner. That means what the outgoing partner has to do according to section 32 of the Indian Partnership Act. The retiring partner, what he has to do? He has to give his what you call he must give the public notice of his retirement. In case if he fails to give such public notice, then it is deemed that he continues to be liable for the acts of the firm even after his retirement. Here, the firm is also not liable for the acts of the retired partner done after retirement from the firm. And the public notice about the retirement of a partner may be given either by the retiring partner himself or any of the partners of the reconstituted firm. Because if one partner goes out, the what the Partnership Act says, the partnership firm has to be reconstituted. Here, the sleeping partner, he need not have to give the public notice because his name nobody knows. That means a retired partner need not give public notice of his retirement to persons who are ignorant that he was a partner of the firm. So there are these are the things we can see. Here with regard to this aspect, there is one very leading important case law, that is Scarf versus Jardine. So here with regard to this one, this is a very famous case law with regard to the public notice. Here the importance of the public notice has been given here. Here I am not going to discuss with regard to the facts of the Scarf and versus Jardine. Here I will make a separate video with regard to Scarf versus Jardine, but I am discussing with regard to the what are all the principles which has been discussed under the Scarf versus Jardine. But similar the facts we can say. That means what we have to see from the case laws, we have to give importance with regard to the what was the principle which has been held in the any case. So that is very much important. More than the facts, we should give importance with regard to the principles outlined in the any case law. So here what I have told you, I have told you with regard to facts, issue and provision of law. Then we have to make the analysis. Here analysis, Scarf versus Jardine is an important case for the principle of holding out, wherein the importance of notice of retirement was highlighted. In this case, the importance of a notice of the retirement was given much importance. The court in this case stated that the retiring partner must give notice of his retirement from a firm in the same manner as a notice of appointment is given, so that people can know about his status with regard to the company, or else he might be treated as a partner by holding out. I have told you what is meant by holding out, what is meant by estoppel. All these things has been discussed. So here this doctrine of holding out is also a branch of the estoppel. That means estoppel means once we project something to the society, again we cannot say no. We can say that such and such a person is our partner. Suppose I being the partner of some firm, if any friend is not related to any partnership firm, I will project him as my partner. Then subsequently I cannot say no, he is not my partner. He doesn't have any relation with our partnership firm. That is, I have been stopped. I have been prevented from taking the wrong defense. So that can be discussed under the doctrine of estoppel and doctrine of holding out. Here, no matter how long back he retired from the firm without notice. Here, time is not the criteria. He might have retired 10 years back also, but he should have given the public notice. So we have to highlight these aspects under the section 32. So under this Scarf versus Jardine, all this aspect has been discussed in length. The court further held that such notice can be given either by the retiring partner or the existing partners of the company. So this aspect I have told you, it may be given by the person who is going to get retired or any partner of the existing the partnership firm. Unless such notice of retirement is given, the liability of a retired partner to old creditors or customers subsists, and the firm would also be held liable for the acts of the retired partner. Here not only the active partner is held liable, but also the firm also would be held liable for the acts of the retired partner. If he makes any, if he represent the what you call partnership firm, even though he has been got retired, if he represents the partnership firm in any contractual dealing, so in that event also the partnership firm will be held liable, because as you know, what is the essential aspect of the partnership firm? What is the main important aspect of the partnership firm? That is the mutual agency. That is the mutual agency. That means the partners, they have got they can become the principal, they can become the what you call the agents. They may become they may act, they may bind the other partners for their acts. So that is the aspect we have seen while discussing the section 4 of the Partnership Act. So there are certain exceptions are there to this rule of the Scarf versus Jardine. Here, so such public notice is not required. When it is not required means when there is a death of a partner, then the death itself it becomes a notice. That means after death, who is going to ask you? That means that is the what you call then it will not be applicable. With regard to the insolvency of partner also same thing. So it will attract section 42 of the Indian Partnership Act. If one has been dormant or sleeping partner beginning to end, notice can be dispensed with as neither the customer nor the clients know of his participation in the firm. And in English law, partnership by holding out is referred to as apparent partnership instead, and the legal provisions in both countries are very similar. In Smith versus Bailey, it was decided that the liability on the principle of estoppel extends only on account of credit given to the firm, not to torts or civil wrongs committed on behalf of the firm. That means there is one more the what you call the decision has been taken in the Smith versus Bailey. Here, no doubt, if the person does not give the public notice, he will be held liable. Their principle of estoppel or holding out will be applicable. But for whichever the aspects he will be held liable means for the credit given to the firm, but not with regard to the tortious acts or with regard to the civil wrongs committed on behalf of the firm. So that is the one more aspect we have to appreciate with regard to the Smith versus Bailey. So what is our conclusion? Conclusion is that X is liable to the credit advance to the firm even after his retirement in the absence of notice to the public. That means X is liable to the credit advance to the firm even after his retirement in the absence of the notice to the public. So this is what we have to see with regard to this problem. If we just write conclusion, then we don't get the marks. That's why students, please follow the steps with regard to the what are all things you have to write with regard to the how to solve the problems under any what you call subject of the law. So this is with regard to the public notice requirement which is to be seen under the Partnership Act.